My name is Bernie Musri. I'm a solicitor specialising in disputes, large disputes and constructions particularly. Today I have joining me Mr. Andrew Clark, a lawyer of some repute, who also specialises in large disputes and construction. Andrew's been a mentor of mine for a number of years, so I'm very pleased to have you here today.
It's great to be with you, Bernie.
Thank you. All right, everyone, welcome to the Caselaw Club. Today, for your viewing pleasure, we have the matter of Robinson and Construction and Design Australia Proprietary Limited 2024 case, the New South Wales Court of Appeal number 314. Now, this case involved a dispute for a cost-plus contract, which we never have problems with at all, do we? In this case, we had the applicants negotiated a cost-plus contract with Design Australia Proprietary Limited. It was a builder for the construction of a residential dwelling in Kiama. The contract was executed in early 2019. The original cost estimate was something in the vicinity of $550,000 because the cost was ultimately much higher than the original estimates. The parties had substantially different recollections of the representations and discussions that were had. Not so much representations, the discussions. And ultimately, the court had to consider whose were more likely to be accurate. Key to their considerations were adduced a number of documents in a packet MFI-4. This packet was adduced on the agreement between the parties that the evidence could be used not as evidence of the truth of the contents of those documents, but it could be used as evidence that that had actually taken place. There were a number of emails in that exchange, in that packet of evidence, and there are a number of documents, formal file documents, which identified estimated costs. At first instance, the court considered whether or not the case was misleading and deceptive.
And this is a natural point, Bernie, to consider. If the parties were to contract again, how might they do things differently to see off what has become a very protracted dispute that's found its way into the New South Wales Court of Appeal, and we can readily assume, I think, that a material amount has been spent by the two parties, quite separately from what's been spent under the cost-plus contract to prepare this matter for hearing and to bring it to the first the primary court and then on appeal to the New South Wales Court of Appeal. And because we know the owners of the property are the applicants in this appeal, we can readily infer that they were unsuccessful and likely to have been facing a cost order for the builder's costs of preparing and running their defence in the primary proceeding. So what could have been done differently? Well, different form of contract.
Yeah, I was going to say, I think the water I'm being led to in this instance is a fixed price contract.
Absolutely. A fixed price design and construct contract is, for parties to a contract that have a strict budget, or a limited capacity to generate additional funds or borrow additional funds for a project. One might have done better not to rely on an estimate, but instead to have some contractual force to a promise about what building this dwelling might have cost.
Precisely.
And whether you're a company or a lay person, consult with a lawyer on contracts that are a material amount of money for you, whatever that is. And, for your primary residence, for 99.99% of ordinary people, that's a really material amount of money. So
buying real property in Sydney or in Australia generally, you're buying more than a square millimeter.
As a relatively new homeowner, Bernie, I engaged solicitors to look after my conveyance.
Well, being a solicitor yourself, I mean,
I wasn't tempted.
What's the old adage? They who represent themselves has a fool for a client.
Yes. Always have a professional indemnity insurance policy and someone else to rely on.
Very reasonable proposition.
But we see that's a gap in the way the applicant has run the primary proceeding. We see that, it's noted in the appeal judgment that no evidence was adduced at first instance, that the owner could have entered an alternative contract for the construction of the home or otherwise sold the property and purchased a house in Kiama. We see that in paragraph 16 of the decision.
Would have been key to demonstrating damages. Yeah. Important point. The original judge preferred the builder's recollection of the events that went forward. However, fascinating. The original judge, referred to this package of documents, which the parties had agreed were not to be adduced as evidence of the facts carried within them. We might refer directly to the appeal decision to consider what the judgment says about the original. Court says, paragraph 44. His Honour described the general approach to fact-finding at paragraphs 22 to 26, noting the contrasting evidence of the witnesses as to whether the alleged representations were made. His Honour correctly acknowledged at paragraph 24 that the contemporaneous documents are generally the most reliable source of evidence as to what has occurred. He added that reference should also be made to the logic of events as revealed by objectively determined matters, including the parties' contemporaneous communications. Now, the transcript confirms that the primary judge was well aware of the parties' agreement in MFI-4. The terms of MFI-4 permitted consideration to be given to the content of each email. I accept the builder's contention that this permitted the primary judge to rely as he did on, quote, 1, the language and tone used in the emails, 2, the form, including the level of detail contained in the emails, 3, consistency and content of the emails with other evidence, that's key, with other evidence before the court, 4, whether the content of the emails corroborated and or confirmed the truth of other evidence before the court. So they've submitted that the court can consider that evidence and the content of it. And this is a fine line because the facts alleged in that, the facts alleged in the emails are conversations about costs, about estimates of pricing. But that content can be used to corroborate other evidence.
And therein lies that right there is the tension. There is the heart of the applicant's appeal. Is relying on the content of these emails in packet MFI-4, is that for the purpose of corroborating, say, oral evidence of the two personnel of the builder that give evidence and are said to have made representations in this proceeding? Is relying on the content of these emails to corroborate oral evidence, relying on the emails for the purpose of establishing the truth of the content of those emails?
It's tricky.
It's a fine line.
It is. Well, in this case, it's a fine line because the emails are conversations about the discussions around cost. So really fine line. You could see situations in which document A, under the same situation, has been agreed to the fact that documentation is approved. Document A proves fact A and document B proves fact B. And document B doesn't talk about fact A or document A, but fact B proves or corroborates fact A.
By virtue of some logical consistency between a matter that is alleged in the email and a matter that is evidenced in some other form of evidence in the proceeding.
Precisely. That's a much less close to the line, I think, use of that evidence. But you can see how that could well occur. All right. So to the outcome of this case, the courts considered that, yes, they've decided, yes, they are allowed to use this form of corroborating logic. And even though the truth that is sought to be proved is actually discussed in those emails, that's not what they've relied on them for. They've relied on them to corroborate other evidence which is in use.
And I'm left wondering, Bernie, if the strength of the other evidence was a factor that both the primary judge and the appeals judges considered. It may be suggested in the primary judgment that the evidence of the builder's personnel was otherwise to be preferred to that of the owners. But I'm wondering, would the same logic be sustained in a world where there were serious doubts about the credibility of other oral evidence? And that's not the case hasten to add, that's not the case in this matter. But if the oral evidence was unreliable for some reason, would the corroboration afforded by these documents be mere corroboration, or might they be, more accurately said to be the evidence of the truth of the matter, and it's the shaky oral evidence that in fact corroborates?
I see your point. This is an interesting case and a useful case because it is so close to the line. So we can see very clearly where the line is because it's close. That having been said, I think, the question could almost go to the probative value of the inference that's able to be made based on that evidence, right? You could view it in that way.
Well, if the oral evidence were not probative and something that could conceivably be accepted on the balance of probabilities, then a corroborating document is not corroborating at all.
Now, what I mean is that the corroborating document's propensity to prove the testimony is the probative value if we approach it from. So the strength of that probative value becomes the key determinator of the weight placed upon it. But then that begs the question, can we proceed down that road without a logical error at some point? Because at some point, as you pointed out, there's going to be a problem where, well, without this piece of evidence which says X tends to prove X, there's a line somewhere there. It's probably pretty close to this case.
Yes, this is an appeal decision, and of course, appeals judges are frequently reluctant to second guess assessments of credibility of oral evidence. The primary judge, of course, has the benefit of weighing up, seeing in person, persons giving evidence, and it's not common to see assessments of credibility displaced. But again, the Court of Appeal doesn't delve into that in this instance. There's there's no aspersion cast on the credibility of the builder's witnesses in this case.
Well, it's easy to say that because it's made it past the threshold. If it hadn't made it past the threshold, then the court would have to delve into exactly where the flaw in logic exists, because this is purely a case about how the evidence may be used. But for what it's worth, this was a new exploration for me. It will probably shift the way I approach these sort of things in the future a little bit. And it seems like it could be an area for opportunity tactically, as well as something to be aware of. Gosh, you would want to be aware of this. But I hope counsel's aware of this case because its effect might be significant.
Well, the preparation of written evidence changes. If a document can't be relied upon or can only be relied upon for a limited purpose, it's then incumbent when preparing affidavit evidence to consistently with the witness's true and honest recollection, independently advance the points, independently recall the matters set out in these documents as best they can, and then only rely on these documents for corroboration. Affidavit evidence gets longer and longer and longer every year, but this might be another good reason to add the belts and braces to affidavit evidence and ensure dot every I and cross every T. Make sure that the evidence is bulletproof.
And then corroborating evidence gets disclosed later or in a supplementary evidence, filing.
or just in a separate paragraph of the same affidavit.
Oh, it's the same affidavit. Oh, yeah.
Oh, well, I a witness can say, I recall a conversation. Person A recall a conversation with person B. I said to them words to the effect of, "This is only an estimate and not a cap on costs." I later sent an email to person B. A copy of that email is annexed herein, and then there's separate pure affidavit evidence of the representation together with a reliance on a document. But of course that will only be possible in a case where there was both a oral communication, a telephone call or an in-person meeting, and a separate contemporaneous written communication. If as commonly happens, parties only communicate by email, well, that avenue won't be available in preparing a case for trial.
I've encountered situations where a witness might adamantly recall that a phone call occurred after that conversation. And then, of course, it occurred before. The preponderance of decisions like this makes me almost wonder whether it supports their original recollection because that phone call did occur and there's a record of it and we can identify it from other evidence, or because of the recollection around the chain of events, it tends to do the opposite. It doesn't corroborate it, but it suggests that they've got it wrong somehow.
Yeah, and skilled counsel will exploit minor inconsistencies in evidence to impugn the credibility of a witness, and that's why lawyers often tell their clients, take a contemporaneous file note. Note the date and time of the interaction you're recording at the top of the file note, and then while that interaction is still fresh in your mind, record the contents. You can also then send an email recording the content of a discussion to another person and give them the opportunity to disagree with, at the time, give them the opportunity to disagree with your recollection of that communication. And of course, in this matter, it just comes back to how the parties have contracted and handled their communications, being very clear about what your budget is and what you need from your contractual counterparty, and controlling costs can play a big role in reducing future litigation.
Interesting one to be aware of.
Absolutely.
That's it for today. Thank you, everyone, for joining us. This has been Caselaw Club.